How are mistakes typically dealt with? The validity of a contract relies on both parties consenting to the agreement and being willing to be bound by the contractual terms. If you discover a mistake in a contract, or one consequence might be that the contract become void about into. That means that the court takes the contract as not existent based on this mistake. Alternatively, it can rule that the practice never lawfully entered into the contract, voiding a contract because it contains a mistake is only one of several options for dealing with a mistake in a contract. Um, this option is only available when a mistake is one of fact or common mistake. If the mistake is more insignificant, the contract may still be enforceable. Mistake of fact can be a factor in reducing or eliminating civil liability or criminal culpability. A mistake of fact is of little consequence unless it is born of unconscious ignorance or forgetfulness. A person cannot escape civil or criminal liabilities for intentional mistakes. In contract law, a mistake of fact may be raised as a defense by a party seeking to avoid liability under the contract. Also, a mistake of fact can be used affirmatively to cancel, rescind, or reform a contract. A mistake of fact can affect a contract only if the mistake fact was material or important to the agreement. In the event of a unilateral mistake, only one party to the agreement is mistaken about a material fact. In such a case, the party adversely affected by the mistake will not be able to avoid the contract unless the other party knew or should have known of the mistake, or unless the other party had a duty to disclose the mistake fact. If a party to a contract assumes the risk that a material fact might be different than expected, that party will not be able to recover any losses when the fact turns out to be different. Mistakes of fact. Mistakes of fact arise when a criminal defendant misunderstood some fact to negate an element of crime. Mistakes of fact may apply to a variety of crimes. Some crimes may set forth the mistake of fact is a defense. Otherwise, if the criminal defendant can prove that the mistake responsible negated an element of the crime, the defense will usually be held to apply and absolve the defendant of liability. Mistake of law. Mistake of law is a defense that the criminal defendant misunderstood or ignored of law as it existed at the time. The onus is generally placed on individuals to be aware of the laws of their state or community, and thus this defense only applies in very limited circumstances. Mistake of value. If, however, the mutual mistake concerns the future market value or some quality of the object of the contract can normally be enforced by either party. And here we have a bilateral mistake. Both parties are misinformed as to the contract meanings and terms. Bilateral mistakes are also sometimes referred to as a mutual or common mistakes. Bilateral mistakes can involve the contract terms or the ability to perform their bilateral mistakes are often violable in court. And unilateral mistake. A unilateral mistake means that just one party is misinformed as to the terms or meaning of the contract. It can be much harder to avoid a contract that is based on unilateral mistake. There are three types of misrepresentations. Innocent misrepresentation, it's a false statement of material fact by the defendant who was unaware at the time of the contract. Who was unaware of at the time of the contract signing that the statement was untrue. The remedy in this situation is usually rescission or cancellation of the contract. The second type is the negligent misrepresentation. This type is a statement that the defendant did not attempt to verify it was true before executing the contract. This is a violation of the concept of reasonable care that a party must undertake before entering an agreement. The remedy of negligent misrepresentation is a contract rescission and possible damages. And the third type is a fraudulent misrepresentation. A fraudulent misrepresentation is a statement that the defendant made knowing it was false or the defendant made recklessly to include the other party to enter the contract. The injured party can seek to void the contract and to recover damages for the defendant. And finally, an adhesion contract is a contract drafted by one party and signed by other party. The second party typically does not have the power to negotiate or modify the terms of the contract. Adhesion of the contract, my bad. Those contracts are commonly used for matters involving insurance, leases, debts, automobile purchases, and other forms of consumer credit. Courts carefully scrutinize adhesion contracts and sometimes void certain provisions because of the possibility of unequal bargaining power, unfairness, and unconscionability. Thank you.